How does a divorce affect a transfer on death deed? Have you ever wondered what happens to a transfer on death deed when a divorce occurs? This is a common question that many people face during their estate planning journey. Understanding the impact of divorce on a transfer on death deed is essential for ensuring your property goes to the right people after you pass away. When a divorce takes place, it generally revokes any designation of a former spouse as the beneficiary on a transfer on death deed. This means if your transfer on death deed names your ex-spouse to inherit your property, that designation is automatically invalidated. Your ex-spouse will no longer have any claim to the property through the transfer on death deed after your death. During your lifetime, you maintain full ownership and control of the property. You can sell, mortgage, or manage the property without interference from the named beneficiary. The beneficiary only gains rights upon your death. So, if you have a transfer on death deed and then get divorced, the law treats your former spouse as if they were never named as a beneficiary. This revocation is immediate, so your property will not pass to your ex-spouse under the transfer on death deed after you die. This change can significantly impact your estate plan. A transfer on death deed bypasses the probate process and supersedes a will regarding the property. If your former spouse is no longer a beneficiary, the property will pass according to the new beneficiary designation on the transfer on death deed. If no new designation exists, the property will become part of your probate estate or pass according to other ownership rights. In some areas, to ensure clarity, you may need to file the divorce decree with the county deed records. This confirms the removal of your ex-spouse as a beneficiary. If the property is jointly owned with right of survivorship, the surviving joint owner retains ownership rights. The transfer on death deed designation applies only to the deceased owner's interest. After a divorce, it is wise to review and update all estate planning documents. This includes your transfer on death deeds, wills, and beneficiary designations. Making these updates reflects your current intentions and helps avoid unintended transfers. From an estate planning perspective, knowing how divorce affects a transfer on death deed is vital. It ensures that your property passes according to your wishes and helps prevent conflicts or confusion after your death. Consulting an attorney to update or cancel a transfer on death deed after a divorce is a smart move to maintain a clear estate plan.